And I was wondering, since you didn't have time to talk about reparations, and it's been a while, I have to be honest, since I've been studying these issues, I was wondering what's your position on individual versus collective reparations, and how do you deal professionally when you have to represent the victims whose views diverge on these issues? And my second question is not strictly legal. It's not illegal, but it's not legal. I was wondering, of course, not you personally, but dealing with victims must be very psychologically burdening. So is there any support service within the ICC to help you out with these issues? Thank you very much.
The dichotomy between collective and individual reparations. I have to say that as part of my mandate, again, I prepare my clients for the fact that reparation will never be individual. This being said, as you might know, the reparations are collective, but with an individual component. So in the existing reparation schemes before the court, the individual wishes are to some extent taken into account. Now, the real issue is not that, is that their wishes are thought at the earlier stage of the process. Now, if it is taking too long for them to benefit from reparation, this wish have necessarily evolved. When you take, for example, a former child soldier who might have been interviewed in, let's say, 2014, 10 years later, of course, it would be much harder for, say, former child soldiers to go back to school or to start studying. So this is the real issue, basically, because as for me, and sadly this is not the case of all, for example, external legal representative, but I've always prepared my clients to the extent that there will not be individual reparation per se, meaning financial reparation. Yes. As to whether the court provides support, no, but we have our own means to cope with what we have to face. And I am actually grateful to you to pose that question, because I think that victims' participation is necessary, because we are the face of the suffering, and victims are why the court exists. And this is why the frustration is growing lately, because in not allowing them to participate effectively, you cut yourself, when you are a judge, from the reality, because it's not on comment by questions posed by the prosecutor or the defense that you can have a clear understanding of the victimization in each case, but it's to allow them to bring their stories directly before you as a chamber.
When you were talking about arms dealing and all the problem of neutrale Handlungen, like, yes, I'm producing arms, but hey, wherever that ends with, maybe I'm not fully aware of, although today we cannot claim that as much as before, because due diligence process in human rights is more now demanding. For you, if you are ICC judge, how would you handle that situation? What will be a requirement concerning mens rea for you in these cases?
The question is especially hard for me, and I always believe that the most demanding legal work is being a judge, because as a representative of one party, I have a very strict, easy way, do everything within the legal frames to support. Then you have to weigh these arguments. Well, as I said, despite the national definitions of mens rea, we have this notion that you don't directly go to certain consequences, but you assume that they may appear, and accept that. Yes, and I think that that depends always individually on the person. And one thing is if someone generally sells arms, one thing is that we have a man standing representing actually a corporation. Yes, sometimes official, sometimes not official, sometimes middleman. And quite easily he may assume how it will be used. Yes. As a defense attorney, I'm very far from the concept that if selling guns is legal, that you put on yourself the responsibility that someone may use it to kill somebody and kill him in an illegal way. Yes, but I think I will avoid your question stating that it's a case-to-case issue and you always have to analyze the evidence. I love this type of analysis and this type of work, but I think that with putting responsibility under all the corporate managers and CEOs, the higher your position, the bigger your knowledge, the more you are expected to anticipate certain consequences. Thank you.
How you interpret the chapeau in Article 7 and Article 8. So whether this is really the acts have been committed in the context of a general policy as such. So this will be the ratio, of course. I don't know what is your position about that.
I think it will depend on the work of the prosecutor. To what extent can it be proven that these criteria have been met? If it can be proven, then yes. But if not, prosecuting just because we would like to prosecute, I don't think that's a noteworthy concept. So yes, in short, I agree.
About the comment about peace and justice, I loved very much your presentation. It's deeply touched most of my interests, and I think we agree, if I understand you correctly, that the Nuremberg principles, due to the mission that was given by the United Nations General Assembly to the ILC back in 1947, which was, if I remember correctly, was to formulate customary international law as it was embodied in the Nuremberg procedures. So this is custom. The form is customary law. The function of the principles is principles. So I think that clarifies. But your conclusion, if I remember correctly, was said that there can be no justice without peace, which is just reversing many of the statements that we have read about it, which usually suggests that if there is peace, there will be justice. I know the ICC suffices somewhere in the middle, saying no peace without justice. What I said is the Catholic interpretation in my reading. So if you do justice, there you can reach lasting peace. But the Catholic interpretation is prone to think in very long terms, thousands of years. In a human lifespan, I think it is, if you are Hungarians, I think you understand the background of my statement, why I would like to make this statement. I think it is very dangerous to say that peace in itself, as a singular value, can be more important than justice, or peace can be achieved without justice. So I just wanted to make this clarification and hope you can react and correct me if my understanding was wrong. And my very quick question to Marius. What can you, or would you make any predictions about that wave of coup d'etats that we have seen in the last few weeks in Francophone, Francafrique? What do you think? Will they continue? Will they have an impact on the relation to the ICC? Thank you so much.
Well, it was not a question, just a comment, so I'll just comment back, if I may. I don't think that you can separate them. What I wanted to point out was that you cannot have one without the other. So that was my submission, if I haven't submitted it properly. I don't think that you can separate, and I understand political reasons, and it would be maybe for a break question, how much political pressure there has been on the functioning of not only ICC but also other international criminal judicial bodies. I am a lawyer, and for me, rule of law, that's very important. And the fact that within the Rome Statute, that is an international treaty, you've got actually included the issue of interest of justice and whether the interest of peace is there as well. It is a legal norm they've got to take into account. That's the reason why sometimes I just look at the decision and as a lawyer I'm surprised, but I'm not a judge. And that's what actually has already been presented by today, that it is a completely different approach then, I presume.
Yeah, thank you for your questions. And I would like to say something quickly about the comment. And we had also this kind of issues in many African countries where elections were not being organized because of the unrest. So for example, let's say you have an ongoing war, local movements that are preventing the tenure of elections. And the government usually come and say, we cannot have the elections. Why? Well, you see, they are fighting everywhere. They're destroying the ballots. We have unrest. So this peace and justice is like, it's a rhetorical and also philosophical question. So for one person, maybe the Protestant, it can be, I don't know, maybe peace comes before justice. For example, so to put at peace this population, to have people to implement order first, sometimes repression, and then organization of elections, for example, and justice, or the Catholic, the opposite. That's my point of view. It's a real question, but I think it's very philosophical, and it's like, which comes first, the egg or the chicken? I don't know. That's my point of view, and it's again very hard here. I think both are very important, but again, yeah, I really love it. We can be talking about it the whole day, and thank you for bringing up this question. It's great. And regarding the coups in Africa, so it's very simple. And I think there will be more coups. And I even can tell you the countries, the next countries. So it's very linear, actually, if you see. So the last one happened in Gabon, and if you have seen what really happened, you have to know that it was a dynasty in power for nearly 56 years. The father first ruled for 40 years, and then the son ruled 14 years, 2 mandates of 7 years, and I think it's quite enough. And, well, he got re-elected, by the way, legally, and he had a 3rd mandate, but maybe the people were just fed up because they were, of course, it's hard now with inflations everywhere in the world. We can put that on the war in Ukraine, but really people are fed up with 56 years and they just want some democratical move, they want a new faces. It doesn't mean that they will have now peace, that they will reach development. It's a path. Evolution, development is a path, but people are just tired of these games, maltreating, lack of democracy in a way. So in Gabon, you can explain it that way. In Niger, it's totally different because, for example, Niger is very rich in uranium. Niger has 7% of the uranium of the world. You see the whole planet, it's a big planet. The Earth is blue and big. And that country has 7% of the uranium everywhere. And they even don't have electricity. So if you know, we are lawyers, of course, but we use uranium for electricity for the nuclear power plants. And they are selling the uranium, 40% of it every year to some big European countries. And the European Union is actually buying them also. And those people, they even don't have access to electricity, the basic needs to trigger the evolution, the development, education. For example, if we didn't have electricity here, maybe we could have the conference because it's summer, but in winter, that would be, I don't know, not so sure. So electricity is very important to achieve the SDGs, right? But they don't even have access to that, but the people are still exploiting, that is just the uranium. And imagine all the other minerals. So of course, over here is, again, I think education, training, because this is business in a way. Business is always business. People don't have to be fair, but I think the states, the European Union mostly, have to, I don't know, to put a bit of heart when they are dealing business, because over here it's just business. People are just fed up. How come we have uranium, we don't have electricity, and they have been exploiting this uranium for years, and we get nothing back? If someone else, be it Turkey, be it Russia, be it China, can take the same uranium and build a nuclear power plant here so I can have electricity to develop my business, let them do it. So it's very simple over here. And of course, France has a military base there, and they're asking them to leave. Ask me why. So if they are suffering with terrorists and no help, no assistance, I know it's very expensive, the military materials. The world have been helping Ukraine, which is great, right? But there are also many other countries who need assistance, great assistance. And this situation was, again, caused by the intervention in Libya by NATO. Very familiar. NATO it has nothing to do with Africa. It's European Defense Group, right? So again, that triggers something else, but then the result, nobody dealt with it. Then the Africans were left alone again, just after the independence. Now you are alone. Rule the country. Oh, well, we cannot rule. Well, we kill some people. We can prosecute you. So you see, so I think we really should sit down and talk. We can say, okay, I come for these materials and I'm ready to pay the fair share for that material and to make sure you can invest it in people. That can be fair. And then we won't see any coups. Otherwise, there will be coups everywhere. And I really can tell you during the launch, the next countries, we can see there are countries coming because people want to have a better life. They really want to achieve the SDGs in 2030, you know. So, yeah, I'm sorry, but it's a reality.
One question to Professor Mariusz Mensa. I would like to ask you about your proposal on the separate chamber of ICC for Africa. I have been thinking about the African citizens and how they would react at this proposal, especially maybe it could be controversial from the point of view of the idea of this modern imperialism. So what would you say about the composition of this specific chamber? It would be recommended to enhance the judiciary representatives from Africa, or you see the Europeans, the representatives of other countries to be judges at this chamber. So you see the specific regime for the chamber inside the ICC, or to base the composition of this chamber on permanent representation having right now. So thank you.
Regarding Africa, so there are extraordinary chambers. There were extraordinary chambers in Africa, in Senegal, as I mentioned it briefly in the end of my presentation, and you will have it in the paper. Definitely, I will focus on it and develop it bigger. So that chamber was a success story because it prosecuted Isenabre, as I mentioned, who was a leader, and maybe due to the success of that chamber, of course, it was a cooperation effort between Senegal, the African Union, and was partly financed technically and financially by the European Union and other organizations. You see, so this is the cooperation we are talking about. So they tried a leader who killed nearly 40,000 people during his mandate. I think it was 8 years. He didn't just like opposition, you know. Opposition is not, you know, I mean, it's hard, it's everywhere. And yeah, so he was tried. It was hard because at first he put in front his right to life and the no retroactivity of law, because the situation we are talking about happened before. So he said, well, why are you trying me now? Because it happened before. I'm now a better man. What I did during my presidency is now behind me, right? So I'm a better man now, and let's just forget that and let's just move forward. But 40,000 people, come on. Right, and people lodged everywhere in Belgium. So if Senegal, so he was in asylum in Senegal. So if Senegal wouldn't try him, then Belgium would due to the universal principle, they would trial him anywhere, and then the African Union took its responsibility together with Senegal, but it was very hard for the country because he was in asylum. It's very important, the asylum law. If you give asylum to somebody, it means you are protecting that person, and now you want to trial that person. So it was very difficult. They have to ask the opinion of the West African court, which first agreed with Abreu, said, yes, it's true, it happened before, but he said, no, for impunity. There's no time lapse. It happened, but you must be prosecuted, and then he was prosecuted and jailed and died in prison. So the success of this case, and the same for Sierra Leone as well, with Charles Taylor, who was tried in Sierra Leone, of course, but in the ICC, and then was sentenced to jail as well, and is in jail in the UK. Recently, he asked to be freed, but during COVID, but I think he's still in the UK. So these success stories means that the African Union, the African countries, because we have our own rules as well, we have our own charts as well regarding the kids, human rights, dealing with African problems, because Africa is big, but it has different problems. Of course, human rights is human rights everywhere, but we have some specificities. For example, the right to development. You guys don't have in the European Union, but we have the right to development. It's very important because they want to evolve, because you have kids who even don't have access to school. So how can we evolve if you don't have access to school? So this is not a problem in most European Union countries, but in Africa, it's a problem, so it has to be coined, of course, in our human rights chart. So I think dealing with African issues, to have peace, not to say, okay, the ICC is pointing at Africa all the time, which can be understandable because of the death tolls that we have mentioned, and these are just a few, but there are many more, right, that I even didn't mention, right? It can be possible just to support this Malabo protocol, maybe to change it a bit, or maybe, I don't know. But it can be possible to have these chambers in Africa, actually, in cooperation with the ICC, the United Nations, and many other regional courts. That's my point of view.
Question to Professor Rao. He was speaking so many about loopholes in the international lawmaking, and in fact, Professor Bill Shabazz, whom we all know and who's a leading expert of the matter, he also considered to discover a loophole, and he wrote an interesting article concerning the Al-Mahdi case, the title of which was, Sir Al-Mahdi made his guilty plea for a crime he did not commit. Because, in fact, the Rome Statute is speaking about the destruction of cultural monument has to be committed during an attack. And according to Bill Shabazz, in fact, the attack was ended when Timbuktu was captured. The problem came back when we were dealing with the Al-Hassan case on a pre-trial level, and there the defense brought back this argument and wanted that we did not confirm that part of the charges because there was no more attack as such. At that time, we considered that, in fact, it's a kind of continuous crime, and also concerning the others as well, so they did not stop with the capture of Timbuktu as such. Currently, we shall see what the trial chamber will say about that, taking into account the whole trial as such. Probably the defense will come back again with this case. So my question is, what do you think about Bill Shabazz's interpretation? Thank you.
In 2017, I guess, I met Professor Shabazz and I personally asked him this question. And I told him that my perspective of Rome Statute is a little bit different because the crimes against cultural heritage shouldn't be in the section of war crimes, but in the crimes against humanity. It should be another subsection of this subsection of crimes against humanity, which would allow us to put the destruction, theft, or other other elements of Hague Convention from 1954 to this part. In this case, would it be possible to drop those claims which Professor Scheibas put? And would it be even easier to us if we would consider this as a crime against humanity? But as we know, it must be systematic attack. And this is the definition which just one attack against cultural heritage wouldn't be a good part of this definition, because the definition of crimes against humanity is much broader. And that's why I would say Professor Scheibas was right. And the only solution would be to adjust or to put some amendment to Rome Statute to find a solution on such cases. But ICC is the court of the last hope. As I mentioned before, the primary role is in the domestic legislation. And if the domestic legislation doesn't cover those crimes against cultural heritage, against art, against cultural property, there is the ICC. But the Al-Mahdi case was the only case just to show that the cultural heritage is something important for the humanity. Was it perfectly legal? No, it was not, and Professor Scheibas was right. But imagine another situation when we wouldn't do anything against this case. We would charge Al-Mahdi with different cases. And it would just show us that the cultural heritage is not the most important thing what we should care of. And this interpretation was just to show that cultural heritage might be the first reason of charges.
Thank you. I just have two questions, if I may be so bold, to Dr. Kecskés and Dr. Rao, respectively. To Gábor, to Dr. Kecskés, you have mentioned the examples where legal personality was given to certain subjects, such as the Wanganui River. There are other examples, for example, in India, for instance. But do these seep into international law? Because at the end of your conclusions, you said that not right now. So can you elaborate on it? Whether do we have any attempts? Because so far I know of one attempt from South America. I think Bolivia was behind it in creating some sort of a tribunal for it. But contrary to its name, it was responsible for handing out recommendations and not legally binding judgments. So do you think international can be interpreted in the midterm or in the long term, in the near future? What are your predictions on the matter? And to Dr. Rao, it's more of a general question regarding cultural heritage. There is an ongoing debate for several decades now on expropriated cultural heritage from the colonial era. And there are several countries, you've mentioned the example of Spain, but the UK and France could also be mentioned, profiting from the wealth or for the art that has been taken away from South America, from Africa, from even Southeast Asia. And those countries are saying that they should either return those or ideally return those and pay some sort of compensation. Whereas these countries will say that the law that would require it, such as the 1954 Hague Convention, didn't really exist, so there is no legal basis for it. Would you be able to remedy this discussion based on our current understanding of international law?
Thank you for your question, András. Yes, Bolivia was the pioneer in this field. During the presidency of Evo Morales, the former president, Bolivia was very active on that issue. So the very first law on the Mother Earth was in Bolivia, and after the Ecuador constitution and the other examples pop up. However, Bolivia wanted to have an initiative in the Latin American countries to make such a tribunal or a treaty, but it was totally a lame duck situation. And later, Evo Morales' presidency ended, and the next president was much more silent and much more cautious on this issue. So yeah, that was an initiative from Bolivia in the Latin American countries, just for this specific region, but it was not adopted, and it doesn't make any sense for international environmental law. Regarding your first part of your question, actually, I don't see any relevant and convincing international initiatives in a way of international lawmaking. What I mentioned, just sporadic examples from Ecuador, from New Zealand, from Bolivia, from Argentina, but I cannot see a big worldwide trend to make it and to include it in an international lawmaking. So I see domestic examples, and I cannot see the threshold of the domestic initiatives which can give to a higher level into lawmaking. As for today, as for 2023, we will see the future later. But I'm very cautious, and it is true that these kind of issues will be in an international treaty in the near future.
This question, which you already asked me, is very interesting because considers very big debate about the source nations and the market nations. Source nations are the countries which are less developed and they are poorer, but they are rich in cultural heritage. For example, Egypt, Peru, Greece, Iran. Those are countries which think the cultural heritage belongs to the countries of origin. On the other hand, there are countries called market nations, the countries which are very well developed but poorer in own cultural heritage, like United States, New Zealand, Canada, also Dubai and Arab countries. And they think that they are the opinion that the cultural heritage belongs to the whole humanity. And in the case of war, if the cultural heritage of one country will be, by any case, found in another country, the host country has the full right to keep it. And this is the justification which we hear since 100 years when Greek claims to recover stolen marbles from United Kingdom. United Kingdom says these marbles belong to the whole humanity. In Greece, they would be stolen or destroyed, and the best conditions for them are in British Museum. In many countries, for example, in the United States, in many museums, there are a lot of war loots from Europe. After Second World War, when Allies went to Germany and France and they discovered art taken by Nazis, they decided to take it to the United States, especially from the territories from Poland or Czech Republic or Eastern Europe, because they didn't want to give this art to Soviet Union. They decided to safeguard this art in American museums, and they are until today. The same case is about the changing of the borders. After the collapse of Soviet Union, many of countries like Ukraine or Poland decided to ask the Russian authorities to take the work art back. For example, after Second World War, the cities like Vilnius or Lviv, which were Polish before the Second World War, were for the 50 years the part of Soviet Union. And a Polish art from this city was now nationalized as a Russian cultural heritage. And after the collapse of Soviet Union and gaining the independence of those countries, many European countries just ask Russian authorities to give this art back, but it's almost impossible. So, just to make it short, the best way is not the international law. We need to be patient if we would like to use international law. The best element is diplomatic law. And sometimes the just matter of one phone call between two ministers of foreign affairs to make the restitution of stolen or looted cultural heritage to the country of origin. It was the case of Sweden, it was the case of Germany, it was the case of French colonies in Africa. And just about the colonies, I've spoken to one Spanish lawyer, and they have completely different perspective. For them, the colonies are not the colonies. This is the part of the Spain. And the whole Latin America was the part of the Spain. Like now, Tenerife or Canary Island. And taking one subject from one place to another was inside one country. So they don't think it's the different thing that the Spanish property. But now, when the awareness of identity, of being the part of the nation is bigger than it was before, those countries like Venezuela, Argentina, Peru, Guatemala or Mexico, they want or they ask Spanish museums to give the art back. And actually the case with those countries is pretty easy because nowadays Spain is eager to cooperate with those countries. The biggest problem is with the United States. United States wants to be a great leader in the terms of the cultural heritage and protection of cultural heritage, but it's very difficult to find the rightful owners of the art which was taken to the United States after the Second World War, because we don't even have the information that the United States Museum exists. And the last thing what you mentioned is just the lobbying. And if some groups of interest in Africa or Canada or in Far East lobbying for returning of art is much more important than the new legislation in the terms of new resolution of United Nations or new international law, because all of the countries just would like to have a positive image in the international area in the terms of credibility. And it's easier to use the diplomatic instruments to recover stolen art than asking international organizations or to create new resolutions of soft law in the United Nations. This is my opinion. Thank you.
Two questions as well, respectively, both professors. Dr. Kecskes, I've got a question concerning draft principles, because you've labeled them as softer than soft law. Nevertheless, the Commission itself has admitted that the set of those principles is a set of customary rules and principles. And from the reactions of states that have said, so decide yourself, how would you call them? Because they have admitted some of them, of course, not at all, but yes, there are customary rules embodied in the principle. So don't you consider that there are some customary rules anyway, or whether you consider the whole set of principles to be softer than soft law? So that's for you. And as for if I made the comment now, I think it is, as for the Spanish understanding, that's understanding of law. Because you would actually admit, using not a nice word, revisionism in relation to cultural heritage. You would have to change legal framework of that era. I'm not talking now about 40s of 20th century. I'm talking about 19th century. So in the 21st century, it would like to change legal regime of the 19th century. So it is not only about effective approach. Of course, diplomacy works much better in relation to cultural heritage. It is issue of law as well. Nevertheless, my question now, because we can discuss much more about it later, I presume that you haven't elaborated more about, you've mentioned universal jurisdiction in relation to cultural heritage. Could you elaborate maybe a little bit more? Whether you mean on what is the legal title, because you've got universal jurisdiction stricto sensu, where you have the obligation, when you have the possibility of a state to prosecute. So what might be a legal title in relation to universal jurisdiction in relation to cultural heritage? Thank you.
Yeah, regarding the draft principles versus draft articles, yes, the working method of the ILC is to get any information and contributions from the states as well, and they just make an analysis of the existing contemporary international law as well. I think that was a very good sign that at first the title was draft principles and not draft articles. Sorry to refer to international environmental law, but we can clearly see it in the case of the draft articles on the international responsibility of states versus on the other part, the liability. In the liability scheme, they just have a draft principles on the injurious consequences of transboundary damages. And they refer to that we just dare to adopt principles which has a very wide interpretation field. And to my knowledge and to my understanding, the two very important elements of soft law is either without clear meaning, so principle or provision without clear meaning, and give floor to very wide interpretation, and or the lack of sanction. And regarding the principles, however, it is based on some customary and state practice-based soft law mechanism, but we actually don't have the exact meaning of the principles behind the principles, because the environmental principles are very, very general and abstract, and there are also no sanctions behind. So I think this, when they decided that we adopt the draft principles, and it is not just a name game. So it is they adopted the draft principles meant that they were not in a position to label them as draft articles, which was even more relevant for soft law mechanism. So I think this, when we name it as draft principles, it is even a sign of a softer terms. And yes, if we just call the Martens Clause for environment, I think it is a very good example that I cannot make any customary nature or maybe even a soft law nature from the Martens Clause today in contemporary international law and in contemporary international environmental law. So it's so abstract when we are referring to public conscience and the interest of the humanity and the humankind with regard to the Martens Clause of the environment. So it is even more softer than the draft articles.
More just the academic discussion about the universal jurisdiction, because as you know from the practice, that must be a political will in the terms of gathering evidence. And if any state party of the Rome Statute would like to reported to the prosecutor's office that the crime against humanity or a crime of aggression was committed, from the practical point of view, it would be extremely difficult in the terms of this airstrike in Turkey. I mean, it would be extremely difficult to cooperate with the country which is not the part of the Rome Statute in the terms of gathering evidence. So I don't think it's possible. I mentioned it might be in the terms of academic, hypothetical discussion possible, but I mentioned before, it's very negative perception of universal jurisdiction in the point of view of political relationships. If one country doesn't have any interest in in persecuting crimes in the country which is not the member state of ICC, the political conflict between those countries would have much more and much serious consequences than the idea of gathering evidence. And I would like to ask you, what is your opinion about universal jurisdiction, because you mentioned it, and I would be more than happy to get your opinion about the practical aspect of universal jurisdiction. And is it the academic discussion, or maybe it's possible? I think it's not, but I would love to hear your opinion.